Very good morning, my students. My name is Advocate Abhishek Chaube, and this is the first lecture on Indian polity, that is Indian Constitution. And in this lecture, we'll try to understand the technicalities and concepts enshrined in the Constitution of India with the help of current affairs. So, first of all, when you hear the word Constitution, what comes in your mind? So let me tell you this, that as a citizen of India, you should know this, that the Constitution of India is the supreme law of nation. So which is the supreme law of nation? It is Constitution of India. In legal terminology, under legal maxim, it is known as suprema lex. Lex means law and suprema means supreme. So it is the supreme law. And when I say that the Constitution of India is the supreme law, now you must be thinking about the Bharatiya Nyaya Sanhita, Bharatiya Saksh Suraksha Sanhita, IPC, CRPC. Then what are these acts? These acts, statutes, codes take their power from the Constitution of India only. So let's understand this with the example. First of all, you will see articles in the Constitution of India, whereas you will see the term section in IPC, CRPC, Bharatiya Nyaya Sanhita or Bharatiya Saksh Sanhita. Why is it so? So let me tell you this. Article is in itself a part, a chapter, and sections are deriving their power, their authority from the article itself. For example, Article 15 Clause 3 says that nothing shall prevent the state from making special provisions for women and children. Means that nothing can stop the parliament, the state, from legislating such laws which are for the betterment, which are for the welfare of women and children. So this is 15 Clause 3. Got summed up in a single line. But these acts and codes, their name are Protection of Women from Domestic Violence, year 2005. This is an act, a whole act, deriving its power from 15 Clause 3. Prevention of sexual harassment at workplace. This is again an act for the protection of women against sexual harassment, specifically in workplace. So these whole acts, and same for children, for example, Juvenile Justice Act, Child Protection Act, these all acts are for the protection of children specifically. So these whole acts are carved out from a single article which is enshrined under Constitution of India in form of Article 15 Clause 3. So now we understood the concept of suprema lex, why the Constitution of India is regarded as the supreme law. Now let's understand this. Another concept. Why I am telling you this? Because I am laying foundation for you. I am targeting the conceptual clarity in the very first class. And when I say supreme law also means that no man is above law. No man is above law. This you will find in rule of law. It's a concept, rule of law, which is given by A.V. Dicey. This can come in your exam. Who gave the rule of law? Who propounded the theory of rule of law? It's Professor A.V. Dicey, which says that no man is above law. For example, Article 14, equality before law and equal protection of law, which says that before law, all individuals are equal. But now you will say that sir, Article 361 grants special immunity to the President against criminal proceeding. Mean to say, no criminal proceeding as per Article 361 of Constitution of India can be initiated against the President during his term of office. So here you are granting a special privilege to the President, which is again based on a concept known as Rex non potest peccare, which says that king can do no wrong. Here king is president or government. So it is presumed, not assumed, it is presumed that the head of a state can do no wrong. But don't you think that this is an infringement of the idea of equality, fairness and justice, which is held in the case law of Maneka Gandhi versus Union of India? We'll deal with this case law in the next class. This is a very landmark judgment, you can write this down. Maneka Gandhi versus Union of India. So this is the infringement if you are granting a special immunity to the president. So it is breaching the idea of equality, fairness and justice. So the Constitution of India gives you the solution for this, gives you the remedy. Article 56 and Article 61 talks about impeachment, talks about the removal of president. Article 61 talks about the procedure for impeachment of president. On which ground? For violation of Constitution, corruption, abuse of power. Means the idea here is very broad. It just says if you violate the norm of Constitution of India, if president violates the principle of Constitution of India, he can be removed. So it has a very wide scope. Being a president, if you violate any particular provision of Constitution of India, you can be removed by the resolution passed in Lok Sabha and Rajya Sabha, in Parliament. So now you understood these three concepts in the very first segment of this class. Now let's understand, you got to know what is Constitution of India. Constitution of India is a set of principles, precedents and fundamentals which helps in governing the country. What is Constitution of India? Why Constitution is regarded as the supreme law? What is the difference between Constitution and other statute code of India? Now, types of Constitution. What are the types of Constitution? There are two types of Constitution. First is codified Constitution and second is uncodified Constitution. When you hear this word codified Constitution means when all the rules, regulations, fundamental principles, provisions are enshrined, are written down in a particular document or set of documents, it will be known as codified. Means you can write in bracket written. Codified Constitution means written Constitution. On the other hand, uncodified Constitution means which are unwritten Constitution. For example, Israel, UK, New Zealand. These are the example for uncodified Constitution. For example, if we talk about codes, if we talk about statutes, law of torts is a classic example for uncodified law. Nowhere you will find sections in law of torts. You will only find common law. You will only find the previous judgment. Previous judgment in law is known as precedent. P-R-E-C-E-D-E-N-T-S. Which is a mandate again under Article 141 of Constitution of India, that all the judgments held given out by the Supreme Court of India will be applicable on every civil and criminal court throughout the country. It is known as precedent. So law of contract is codified because you will find sections in Indian Contracts Act. You will find all the remedies in case of breach of contract, in case of any breach of particular provision of an agreement. If there is no consensus ad idem means agreeing upon same thing in same sense. Mistake of law, mistake of fact. So that's a different topic, we'll deal it with later on. So understood what is the difference between codified Constitution and uncodified Constitution? It's simple. Codified means written, uncodified means unwritten. Now let's proceed further. Now the very important thing in Constitution of India is the preamble. What is preamble? If you are through with the concept of preamble, you will be able to comprehend the whole provisions and concepts enshrined in the Constitution of India. So preamble is the soul of Constitution of India. What is the importance of preamble? So preamble acts as a prologue, as an introduction of Constitution of India. Whenever you read a novel, any book, you will find a first page which talks about the introduction of the book, what you'll find in this book. So same thing is done by the preamble enshrined in the Constitution of India. And under various case law, for example, Keshwananda Bharti versus State of Kerala, A.K. Gopalan versus State of Madras, and Axel Weir versus Union of India, Supreme Court unanimously held that the preamble acts as a guiding star for interpreting the Constitution. Means what? Under all the 511 articles in Constitution of India, if there is any inconsistency, repugnancy, or if any scholar or judge finds difficulty in interpreting or comprehending any particular article, he'll take the help of preamble of Constitution of India. So this is the importance of preamble. So first we have to understand the preamble word by word, so that we'll be able to relate the word secular with the UCC. So we'll talk about Uniform Civil Code under Article 44 of Constitution of India, which is falling under the purview of directive principle of a state policy stretching from Article 36 to Article 51. So what is preamble? It starts with "We the people of India." This expression has been borrowed from the US Constitution. We the preamble starts with "We the people of India." Means what? It's we the people of India who have taken this decision that we are now formulating a Constitution of India according to which will be regulated. No political party, no scholar, or no monarch taking this resolution, but we the people of India. So by this very first line, we can understand the rule, we can understand the form of government which is democratic. Democracy is a government for the people, by the people, of the people. This definition perfectly apt to understand the concept of democracy given by the Abraham Lincoln, who was the 16th president of US. So with the very first line of preamble, we understood the concept of democracy. We the people of India, expression taken from US Constitution. In whole world, there are only two constitutions which starts with "We the people of US" or "We the people of India." Only two constitutions, US Constitution and Indian Constitution. So we the people of India, having solemnly resolved to constitute India into. So it's we the people of India having solemnly. What is the meaning of solemnly? Solemnly means solemnly, to take any action with seriousness or with deep respect. So with seriousness, we the people of India having resolved means to take a strong decision, to take a firm decision. We the people of India with seriousness, with due respect, have taken a firm decision that we the people, we are constituting India into sovereign, socialist, secular, democratic and republic. So what is the meaning of sovereign? Sovereign means no external pressure. We are free to decide our country's political destiny. Because we are not sovereign, we are not subject to any external power or any foreign government. We don't need to take any permission now. Because we are not anyone's slave. India is an independent country now. Then comes socialist. Socialist means what? So here comes the main key to understand the Constitution of India. Socialist means, so in the case law of A.K. Gopalan versus State of Madras and D.S. Nakara versus Union of India, it was held by the Supreme Court that the word socialism enshrined in the preamble of India is a blend of both, is a mixture of both Gandhian ideology and Marxist ideology, while heavily inclining towards the Gandhian ideology. And what is Gandhian ideology? It's upliftment of weaker section, that's it. And when I say upliftment of weaker section means, you can understand women, children, EWS, OBC, SC, ST. You'll find ample number of articles specifically talking about women, children. We have just seen this example under Article 15 Clause 3. EWS, economically weaker section, other backward classes, scheduled castes, scheduled tribes. So why there is a special privilege granted to them? Because Constitution of India talks about upliftment of weaker section. Why? So where you have made the heading Constitution, right beside that the objective of Constitution of India is to achieve a welfare state. What is the objective? What is the motive behind drafting the lengthiest constitution of the world? So India's constitution is the lengthiest constitution in the whole world. The motive was to uplift the weaker section, uplift the downtrodden, ensuring the justice from cradle to grave. As a citizen of India, I cannot say this ki, why should I give up my seat for a SC candidate? I cannot say this. Why? Because it's a fundamental duty under Article 51A. And you'll find the word fraternity in the preamble of India, which is talking about common brotherhood. And as a citizen of India, it's my fundamental duty as per Article 51 Clause A subclause E that I have to promote brotherhood, fraternity. So I have to work for upliftment of weaker section as a citizen of India. So understood the word socialist. Now secular. Democratic, we already understood with the very first line with the people of India what democracy is. Republic means easy, all the important governmental heads will be elected directly or indirectly by the people of India. Now we are left with the last word, what is secular? Secular means that India as a country, India as a state has no religion. India has no religion of its own, but it celebrates all the religion, but it respects all the religion. For example, if you'll go to Myanmar, you'll find Buddhism religion, which is prevalent throughout the territory of Myanmar. Sri Lanka, Buddhism. Nepal, Hinduism. Pakistan, Islam. But in India, you'll find the diversity. You'll find ample number of religion, communities, creed, religion. Why? Because Article 25, 26, 27 giving you this fundamental right that as a citizen of India, you have a freedom of belief, faith, worship and religion. It's on you. So why India is a secular state? Because of its diversity. So understood, India as a state has no religion of its own, but it respects all the religion. That's the beauty of India. So now, as Uttarakhand has become the first state to talk about the implementation of Uniform Civil Code under Article 44. So first of all, let's understand the concept of fundamental right and directive principle of state policy. So we have understood Article 14. We talked about Article 21. We talked about Article 15, Article 15 Clause 3. These three articles are falling under the purview of Part 3rd. Part 3rd of Constitution of India talks about fundamental rights from Article 12 to Article 35. And after that, Part 4 is stretching from Article 36 to Article 51, which talks about directive principle of state policy. So firstly, fundamental rights are justiciable in nature, means to say they are enforceable. If a state violates your fundamental right, you can directly approach the Supreme Court of India, which is regarded as the apex court of the nation, which is the Supreme Court. Under Article 32, you have this power that you can approach Supreme Court. Why? Because your fundamental right has been violated. So you can exercise your right of locus standi. Right of locus standi means right to appear before court. Why? Because I am the victim. Because my fundamental right has been violated by the state machinery. Because the law itself gives you the power. It says that ubi jus ibi remedium. Where there is a law, there is a remedy. Where there is a wrong, there is a remedy. So wrong has been done against me. So I have come here for seeking remedy, for seeking solution. Understood? So ubi jus ibi remedium, very important maxim, legal maxim. So DPSP is non-enforceable. Why? Because it is having just persuasive value. These are in the form of directives. Name itself signifies that these are mere guidelines, directives, which are not enforceable. If state is infringing your DPSP, you cannot approach Supreme Court. Why? Because these are just guidelines. For example, while pronouncing any judgment, Supreme Court, the part of judgment which acts as a mandate that we have talked about Article 141, that every judgment pronounced by the Supreme Court of India has to be applied in every civil and criminal code. It's a mandate under Article 141. So that part of judgment, ratio decidendi, obiter dicta and stare decisis, these are three legal terminology, very important. So the part of judgment which is binding on every civil and criminal court is known as stare decisis, is known as precedent. And other remarks, other opinion of Supreme Court of India will be regarded as obiter dicta. Why? These are not applicable. These are not to be applied by every civil and criminal court. Why? Because these are just remarks having persuasive value in form of guidelines. Same with fundamental right and DPSP. DPSP are just guidelines. So under DPSP Article 44 comes, which talks about Uniform Civil Code. Uniform Civil Code says that uniformity of law, that the law will be applicable on every citizen equally, irrespective of his or her religion. For example, in current scenario, there are certain topics, for example, marriage, divorce, succession, inheritance, which are governed by the personal laws. For example, Hindu Marriage Act 1955, Muslim Marriage Act, Muslim Succession Act, Hindu Adoption Act, and Guardianship Act. These are the personal laws. Hindu marriage law will govern the marriages between Hindus. Muslim law will govern the marriages between Muslims. Parsi Marriage Act will govern the marriages between Parsis, and so on. That you can find this example, you can understand this example, that under Hindu law, Hindu marriage law, monogamy is allowed, permitted. That a man can only marry one woman and keep only one wife. If he marry another woman during the lifetime of his spouse, his first wife, then he can be made punishable under law, under section 494 of Indian Penal Code, which punishes for bigamy. Bigamy is an offense. But on the other hand, Muslim can keep up to 4 wives. Why? Because Muslim personal law, Dirar Nisa, gives you the power, gives you the right, you the special privilege that you can marry 4 wives at a time, 4 women. So on one side, you are giving monogamy as a mandate, and on the other hand, in Muslim law, it is permissible to keep 4 wives. It can be an example of discrimination. So if Uniform Civil Code comes, it will allow only one practice throughout the nation, monogamy or polygamy. More likely, monogamy will be take the form of legitimate provision, not polygamy. So still it's a topic for debate, for discussion. But what is important for us is to understand Article 44, what is Uniform Civil Code? What is the difference between Constitution of India, statutes, codes, and personal laws governing each particular religion specifically? So, in this lecture, I have just laid down the foundation. I just wanted to make you conversant with the main elements, concepts of Constitution of India. So in the next lecture, hopefully, we'll start with Article 1 and we'll understand more new concepts, doctrines, maxims, theories propounded by various scholars, articles, and we'll understand the articles with the help of landmark judgments. So take care, see you in next lecture.